Attorney's resource. I have no clue what that music's from, but I'm sure my man Jeff is going to tell me later. Oh, Matlock, gotcha. See, I just dated myself there because I remember that show. All right, we're back with the Honorable Susan Finlay and Kim Werner with Family Law Mediators, Divorce Mediation Group. And we were talking before the break. We were kind of getting a little bit into mediation and domestic violence. And so, Kim, do you guys have a process? I mean, when someone comes to you, they voluntarily decided to go to mediation. Yes. What happens then?
Well, the first time I ever hear from someone, it's overwhelmingly it's on the phone.
Okay.
They call for information. If they're interested in pursuing mediation, I have a sheet of questions I ask, such as how long have you been married, any minor children, etc. And two of the questions on my intake sheet are there any restraining orders in effect, and does your relationship have a history of domestic violence, or is there domestic violence currently occurring in the relationship?
Okay.
And if people answer that question different ways, depending on if they are a person who has been injured or who has suffered the domestic violence, as opposed to the person
who's inflicting it.
Yes.
Okay.
So, so sometimes someone will say, "Well, yes, there was an incident a few years ago." So I explore that a little bit more. And basically, after I talk to them and I get a feel for what their situation is, if there's really any indication of any possible problem that may come up in mediation, I then go on to tell them about a process that we have in place. We call it pre-mediation screening. We call it pre-mediation coaching. I kind of call it what I think might fit best for the person I'm talking to on the phone. And what that is before the joint mediation session starts, because all mediation is held in, both parties are together with the mediator.
Okay.
So the parties don't meet with the mediator separately, they meet together. So before that happens, we set up a pre-mediation appointment for each of the parties individually with the mediator to find out what issues may spark maybe a flare-up of tempers during the session.
Okay.
The mediators will often ask, how do you argue? What kind of arguments do you have? What kind of fights do you have? When was the last time you had an argument? What's happened in the history of your relationship? Is there a specific issue that's going to cause concern? Do you have concern about being in the same room with this person? Are there any safeguards in place that we can help you with? Basically, an overall look at what's happening in their relationship now, and our goal is to ensure that the mediation takes place in a safe, open environment, and that both parties are willingly participating, and that neither one is either physically afraid of the other, emotionally afraid, and there's not a large power imbalance that would impede the process. So part of finding that out is doing this pre-mediation screening. And that's for the mediator's benefit too. We don't want to send a mediator into a situation in a room with two people where there's a possibility that someone is going to become angry, may physically hurt someone.
Yeah, because you guys are on the 17th floor, right?
Exactly.
Yeah.
Right. So we do as much as we can to set it up so it's the safest, most open kind of environment possible.
Okay, got it.
There is no bailiff, there is no metal detector at the front door. This is not court.
Right.
So it's very important that this preliminary screening process take place, but when I have a new case, people I've never met, I always ask that they go into separate rooms after they arrive, and I meet with each of them, even if it's just for a few moments, to ask if they are there voluntarily, if they're afraid, if they're there under duress. In other words, the other person has said, you better go there, or else. Are they there because they want to be? Are there any concerns that they have about being in the same room, sitting across the table from their spouse or the father or mother of their child? And then we explore that. I've had people burst into tears that they're so stressed about being there that they absolutely can't continue. And so you talk that through. I've had people who really cannot be in the same room with the other person. They can't sit at the table, but they can function. They're there because they want to be. They don't want to go to court. They do want to resolve their problems, but it's better for them to be in separate rooms. Right. So when I meet with them, I don't do a written screening. Experts say if you have a written set of questions and there is a power imbalance going on, the controller will say, what did you say to number 4? What did you say to number 5? In other words, it's another platform for potential abuse. So I keep it very informal. nothing written down, but I have a sense of, is this safe to proceed? What kind of situation are we talking about here? And if it's situational violence, for example, they had a big fight because they're going to get a divorce, and one threw things at the other, and the other keyed the car on their way out, or whatever it is, that we can deal with. But if it's involving guns, any other weapons, I would say, strangulation, threats to kill, these are the things I want to know about. These are lethality factors.
Okay.
So if those are present, then I think it behooves any mediator to say, I think your issues are so serious, you'd probably be better served by seeking an attorney, so on and so forth. If it's not that situation and you decide to proceed, it may well be there is a power imbalance, and that could be the case where you say, I'm willing to proceed, but only if you show up with a lawyer, or you bring your therapist, or you have a support person. And I've had cases where one party or the other has brought a support person. One was a friend who just sat there and read a book, but she was there.
Right.
And that made the spouse, the wife, feel better. So you do an initial screening, but it's an ongoing process. So every time they come back, I meet with them and ask, has anything happened since the last time we were together that would interfere with you going forward being in the same room with your spouse?
Okay.
And because sometimes between appointment 1 and appointment 2, there could be some kind of blow up.
Right.
If there is a restraining order, mediation is no exception unless it's part of the order. So
Okay.
if there's a restraining order in place, the couple has to go back to court, the protected party,
Right.
and get an exception, and it needs to be specific. With mediator X at 730 B Street, Suite 17, at the appointed times, because if it's not really clear, one will call the other at 2 in the morning and say, let's mediate, and not feel he or she's in violation of the order. So you need that modification, and once we have that, in those cases we can proceed. It's also very important to do an ongoing assessment, as I said, but if you determine this is not a good case for mediation, you don't want to phrase it in such a way that it sets them off.
Right.
And so you can say, your issues are so complicated, you need more advice than I can give, or something to that effect.
You're flipping nuts.
But if you take the case,
That's why I'm not a mediator.
if you proceed with it, then you have to think about safeguards that you can put in place. And some of the safeguards can be separate rooms. These might be good cases for that, some of them. I had one where the woman was intimidated, and I said, you're wearing glasses. How about this? If you take the glasses off and put them on the table, that'll be my signal to call a break. We go into separate rooms. Would that make you feel better? And she said yes. We went ahead, we mediated for 2 hours. Afterwards I said, you never took your glasses off. And she said, I didn't need to, just knowing I could.
Right.
Gave her that much control, or the control that she needed. So you can have a situation where you always keep your eyes on the violent one or the offender, and that means that person arrives first and leaves last.
Okay.
You don't want any incidents on the street or in the parking lot. You can make that type of tailored approach to the situation that you find in your hands. But I think the big question is deciding, is this case safe to proceed, because it isn't just the parties, but it's also staff. I mean, we're talking about a lot more people than just the parties involved if it's a safety issue. So
Right.
certainly record checks can be done, and a case history, and using a high conflict lethality list, which includes weapons, threats to kill, drug use, substance abuse. These are questions that we need to determine, because, or mental illness. I have had cases where all of the above were involved that were not suitable to proceed.
Yeah, maybe a big X across the. So, the definition, basically, I mean, because domestic violence is a broad spectrum, right? I mean,
Yes,
you have
they're
anywhere
all
from like,
there's
you
all
know,
different situations, that's
but
right.
but the kind of the defining line there for, without going into too much, the whole checklist is any kind of lethality or anything like that, where someone's threatening, there's been, like you mentioned, drug use, alcohol abuse, physical
Mental
violence,
illness.
mental illness, and stuff
Yes.
like that. That's it.
Emotional abuse, how about without touching, but severe emotional abuse, berating the other party, demeaning them, calling them names, abusive verbally.
All right. Well, when we come back from the break, we're going to come back more with the Honorable Susan Finlay and Kim Werner with the Divorce Mediation Group, the National Conflict Resolution Center. Stay tuned for more Inside the Law with Vince Scuncio, the Attorney's Resource. We'll be right back.
We could talk about the
Vince, your phone rang. Do you want to look at it? Not sure if it was a very important call.
Oh, probably not. It's probably my son saying that he's home. Yeah, it was. You can walk around and take photos as well.
Okay,
so if you
yeah.
want to take photos as well.
Yeah, I did take a whole bunch at the beginning, so I was going to take some more too.
Yeah, just get video on them and everything like that. So don't feel weird about
Confined,
walking around.
yeah.
All right, so we've talked about the domestic violence aspect of it. Where do you guys want to go with it from here?
What do you think?
Well, I'd like to talk about why mediation can be better than court for a domestic violence case.
Okay, I
And
like
then
it.
the effect on children.
The effect of children.
Okay, I'm good. I love the stuff you come up with, Jeff. Hey, thanks for tuning in to Inside Law with Vince Scuncio, the Attorney's Resource. We're live on ESPN 1700 here today in beautiful San Diego. My special guest today is the Honorable Susan Finlay with the National Conflict Resolution Center, Divorce Mediation Group, and Kim Werner, who's the program manager over there. And again, thank you, Your Honor, for being here today. It's a great honor for me to have an actual retired judge or judge. Regardless, so if I get a little tongue-tied, it's just because
Okay.
it's a little different situation for me here. I don't get intimidated by people very often, but I'm happy that you're here.
I'm trying to be unintimidated.
Not wearing the black robe has been wonderful. Thank you for that. Okay, so we were talking before the break about mediation and domestic violence, and I always say during the breaks when we have the best conversations, where we're talking about different things. You had made a note, a statement as far as mediation actually being beneficial in most domestic violence cases, where with the criteria that we discussed before being the exceptions. Can you elaborate a little bit on that? Because
Sure.
for me, I would think that if I was in a situation where there's domestic violence, which I grew up with that, my mom, without going in too deep, we had the stepdad that liked to beat us and shoot at us and stuff like that. I can't imagine that being a healthy environment for the two of you guys get together.
Not with the
discuss it.
shooting.
Yeah, the shooting was a little over the top, but so be it. But can we talk a little bit about that?
Sure. Formerly, it was always assumed that domestic violence cases should be heard in court because it's safe. There is a bailiff, there is a metal detector now, and so forth. But the research has indicated that many domestic violence incidents are in fact related to court events. For example, the service of the summons and the petition blow up. Approaching court date, stress rises, tension rises, blow up. Facing perhaps losing custody of your children, another blow up. Waiting for trial, blow up. So if you can get the people away from the stressors of court, assuming you can do an assessment that it's appropriately safe to continue, it's less stressful than court because they themselves are working out whether it's a parenting plan, division of property, spousal support, child support themselves.
Right.
And that can be empowering, regardless of any power imbalance. It can be empowering to both parties to say, we're taking the reins on this. We're going to figure out our own lives, not somebody else telling us what to do.
And you're not on their time frame either, right? Because in mediation, you don't have like hardcore days and stuff like
Exactly.
that.
There's no, you're not on court time.
Right.
It's at their own pace. If they're ready, they come in. They may want to wait a little bit. They may be in therapy. The mediator may say, one suggestion is, why don't you get into have your children in therapy if the children are suffering, or whatever it may be. So yes, it can be very advantageous, but I mentioned the children, and I think one of the best reasons is that you can focus more, in more detail, on the children. And most parents, whether they have been violent or not, emotionally or physically, care about their kids.
Right.
There are sociopaths who don't, but those are not the type of person that we would want to try to have a mediation at all.
Right.
We're talking about someone who's been in a situational, violent situation, responding to shock, trauma, being told, I'm leaving you and you're never going to see the kids again, things like that. There's a blow up, things get thrown around, maybe punches or slaps, but that's it. We're not talking shooting
Right.
or
Yeah.
strangling somebody. So this type of couple, once the uproar settles down a little bit, can really focus on the children and the children's interests, and how important it is to not expose the children to any further uproar. Research shows that children's brains are developing until early 20s. Exposure to domestic violence, verbal and physical, interferes with that brain development. These are the kids that don't do well in school. They're angry themselves, they're scared, they're depressed, they have low self-esteem. It's post-traumatic stress syndrome. They have been exposed to war. And yes, substance abuse is self-medication because they're hurting so badly. And these are a lot of the kids we see getting into the juvenile system because they've used substances to try to medicate, to try to feel a little bit better because they feel terrible. And why wouldn't they? Their parents have been at war. I used to volunteer, or I have in the past, for Kids Turn, which is a program for parents and kids who are getting a divorce. And one little girl, I still remember, she was about 6 years old, when I said, are there any questions? She raised her hand and she said, why do mommies and daddies hurt their kids? And once I determined it wasn't physical, my response was, sometimes mommies and daddies are hurting